All right. So I see it's 12:01, so we're going to start. So um, we'll continue to admit people as they join the room. So welcome everyone. I'm Michael Young. As you know, I chair the privacy and cybersecurity group here at Morris Banning and Martin. I'm joined today. We're doing a group presentation with the two associates in the group, Nick Schmidt and Jordan Ockelberry, who many of you will have worked with in the past. So we are going to talk about new privacy laws and how businesses should prepare. We've slated this for 30 minutes. We're trying to keep it tight, focused, practical, business oriented. We may go a little bit long, but we'll try not to go too long and keep it to the promised half hour. So the thought is you provide the lunch and we provide the learn. So it's kind of lunch and learn session. So we're going to talk about a number of important laws, of course, and just to cover off the obvious point, the opinions we express are our own and not actually legal advice. So our agenda briefly is we're going to talk about the 5 comprehensive state privacy laws, which are now in effect across the country, the applicability of each law, some of the key obligations and rights and enforcement considerations around each of those laws, data subject rights, which is an important topic in those laws, and then the real important stuff, next steps. What do you do about it? How do you start to get your organizations compliant and working towards compliance with these laws? In many cases, the timing is not, there's not much runway with the timing, and we'll start to understand that shortly. So quick overview, the environment today. So California kicked off the party with a privacy law, comprehensive privacy law, I think I want to say it was 2018 or 2000, I think it's July 2018 when it was first enacted. Since then, the California law has gone through a number of iterations, and they have a much more comprehensive version of their state privacy law that is coming into effect in 2023. Next is Virginia, which enacted a law and a similar comprehensive privacy law, and that law is going to be in effect also January 1, 2023. Then we have Colorado and Connecticut who joined the party, and Colorado and Connecticut's privacy laws are taking effect in the middle of next year. So you have 12 months instead of 6 months to prepare for those laws, in theory. And then finally, Utah also has gotten into the act and enacted a comprehensive privacy law. Their law substantially comes into effect December 31, 2023. Practically 2024 for all intents and purposes. So those are the key critical dates, like so. There you go. And now Jordan is going to talk about how these laws apply at a high level. One thing to add here is there are things to say about general applicability. In each of these laws, though, there are unique exceptions and exemptions that might apply to some clients in some circumstances, depending on the particular data that they're dealing with. So in particular, if you're dealing with data that's regulated under another comprehensive law, like HIPAA data, education data under FERPA, financial data under Graham-Leach-Bliley, you may find exemptions that are targeted to those particular industries in these laws. But to talk about general applicability, Jordan is going to take it away. So go, Jordan.
Thank you, Michael. So one of the big questions we're talking about today is who these laws apply to, starting off with California. The CPRA deals with, is applicable to businesses who do business in California and meets any one of the three requirements, including has an annual revenue threshold exceeding $25 million, buys, sells shares, collects the personal information of California residents exceeding 100,000, or has derives their 50% of the annual revenue from the sale of data. What's interesting about the CPRA is that general household data is exempt from the consumer right to delete, the consumer right to correct, and the right to access. And this provision allows businesses a little bit of reprieve when multiple people are connected to the same personal information. Next, we'll look at Virginia and Colorado's data privacy laws. They're a little bit similar, as Virginia ended up modeling the form for the rest of the privacy laws set to be enacted. So Virginia and Colorado, we see the elimination of the revenue threshold, and businesses subject to this law need to process a minimum of 100,000 consumers' personal information. However, if you are a small business who doesn't process this much information, you may still be subject to these laws if you derive some part of your revenue threshold from the sale of data and process 25,000 consumers' personal information.
And kind of the big story, the big theme here is that these laws apply to businesses that are large, right? If you're dealing with the information of 100,000 consumers a year, the thought is you've probably reached a certain size and threshold that justifies the imposition of privacy obligations on you. The second rationale is obviously if you're engaged in the sensitive practice of selling information, if that's your business and you're deriving revenue from the sale of information, then the lawmakers care less about whether you're big or small. They think you should be subject to the obligations of the law. So that's the big theme, I think, that's reflected in these policies.
So next we turn to Utah. We see, again, similar to California, a revenue threshold minimum. So for businesses subject to the UCPA, you need to have at least $25 million revenue, and then also process the data of 100,000 consumers, or have a revenue threshold of data sale of 50% of gross revenue and process at least 25,000 consumers. And finally, Connecticut, we see modeled after Virginia and Colorado, the elimination of the revenue threshold and process it. You need to be able to process at least 100,000 consumers, or if you don't do that, again, small businesses who derive some revenue, 25% at least, and process the data of 25,000 Connecticut consumers.
And one key here as well is this concept of controlling the data. So it's not expressed in this chart, but if your business is a B2B business and you are only processing consumer data on behalf of your business customers and limiting your further use of that data, you may have and will have an argument that you are not subject to most substantial provisions of these laws. So the law might apply generally in some technical sense, but you might be exempt from the obligation to have a public notice, for example, or to respond to data subject rights. So that's an important kind of half exemption, if you will, to the applicability of these laws for businesses that are business to business. Okay, so Nick's going to talk us through an important new concept that has appeared in these laws. So Nick, take this away.
Yeah, one of the major themes of this next year in data protection in the United States is the arrival of European-style data protection rules to the US. And one of the best examples of this is the creation of a new subset of personal information called sensitive personal information. This is a subset of PI that is just limited to information that legislators are particularly concerned about and particularly concerned that a company may abuse. Generally, although the definition varies widely by state to state, There are generally four large categories. The first of which is demographic data and other related types of data that can be used as a basis for discrimination, things like race, ethnicity, religion, philosophical beliefs, sex, life, union membership, health data, things of that nature. The second of which is biometric data and identity theft related data. That's stuff like breach reportable PII, social security number, credit card, etc. Biometric data, things of that nature. The third of which is United States versus CATS type surveillance data. So that's things like the contents of your messages, your precise geolocation data as tracked by a company, for instance, geographically oriented advertising, something of that nature. And the last of which is COPPA type data, or the data of a known child, as Virginia, Colorado, and Connecticut all put it.
So why is the category crucially important? What obligations are tied to the category?
Yeah, the category is so important because it creates a lot of European style obligations now in American data. The biggest of which is the requirement to run a DPIA, or Data Protection Impact Assessment, which we've already seen in Europe. And that requirement really just, anytime that you want to deal with any kind of this data, these pieces of data, to comply with that requirement, you're going to have to put that new proposed use or data collection in front of your legal and compliance folks. And they're going to have to sit down and they're going to have to look at what you're doing and determine, is this use of data the most narrowly tailored use of the sensitive data that I can have? Is this use of data overly burdensome to somebody's personal rights? Am I infringing on their privacy in a way that they would find unacceptable?
Yep.
That's the real big one. There are also consent issues special consent issues that we'll discuss later in the presentation that attaches to this category of information.
So this is going to be a fun importation of European style DPIAs into American law. So, okay. So Jordan, tell us about some of these new data rights, and one comment about the chart generally. So we've made an attempt, as everyone can see, to conceptualize the rights in these laws in a nice, neat chart. In some ways, the rights are messier than is reflected in the neat chart. So for example, you could argue that California's concept of an opt-out of sharing is similar to Virginia's concept of an opt-out of targeted advertising. The reasons it is expressed this way in the chart is because these are the actual concepts you find in the literal text of the law. So there you go. Lawyerly caveat aside, Jordan, talk us through some of what's going on here.
Thank you. So across the board, we see these laws applying or giving consumers the same series of rights, including the right to know what information is being collected about them, the right to access and delete their data, the right to obtain a copy of their data, otherwise known as data portability, the right to opt out of sharing or the sale of their data, and targeted advertising, with the limited exception of California. If you look at the UCPA, they offer a similar right to deletion as California, except for data, but it only covers the data that consumers provide directly to controllers. Data that controllers collect from third parties or inferences that they develop internally are exempt from this rule.
And this is a question we get a lot in the practice, which is, tell me the minimum standard, and if I meet that minimum standard, can I rest assured that I've complied with all these other laws? Sometimes, like, European law gets mentioned in this context. And the problem with that, as much as we would like that to be true, or we would like the assumption in the question to be true, the problem is you have these little nuances in how these rights get interpreted, right? The kinds of exceptions that are available to the right of deletion, the scope of the right of deletion. And you've got just enough of these little differences in these laws that you can't just design a program to one of these laws and expect that you're going to have compliance across the board. You may get close in some areas, but there's just enough differences to keep it, to guarantee that approach won't absolutely.
And I'd say with the publication of new CPRA regulations in California yesterday, you can't even really rely on your CCPA program as a basis.
Yeah, that's true. Your existing California program is not going to be adequate for overall compliance. And as Nick mentioned, the new regulator in California issued new regulations. I'm sorry, new proposed regulations yesterday or the day before yesterday, and which may change several times between now and the end of the year, which just adds another layer of implementation complexity. So, okay. So why don't you talk us through, Nick, some of the obligations on businesses under these laws?
Yeah, no problem. One of the definite common threads in all of these laws is the idea, except for Utah, is the idea of data minimization and the related concept of purpose limitation. Under data minimization, you can no longer collect data willy-nilly or in large part or in large gross. You can't just collect a bunch of data that you think you might use later. Now, every data collection that you perform must be tied to a point in your privacy policy and be narrowly tailored to achieve whatever goal you set out in collecting that data. So for instance, if you're collecting emergency contact information, you can only collect information necessary to facilitate that emergency contact. You can't collect extraneous data like what car they drive or what kind of dog they have. Or those are kind of ridiculous examples, but they're relevant.
Yep.
On the same note is purpose limitation, which is a theme once again in every single one of these laws except for Utah. Under this,
and by the way, in Utah, it may be implicit. It may not show up as a checkbox on this chart because the concept isn't expressed in the way it is in the other laws, but there's still arguments for implicit requirements in a lot of these laws as well. And by the way, when we're talking about data, we're always to be understood to be talking about data relating to individuals and, or in the case of California, households. So yeah.
So I would say purpose limitation is a related idea. Purpose limitation works essentially now. Anytime that you use data, you can only use it for something that you've disclosed to a consumer. That we may use your data for this purpose, which means that you cannot use personal information for any topic that is not covered in your privacy policy, which is why it's so important to redo your privacy policy in anticipation of these laws and to now write your privacy policies with perhaps a more future-oriented focus, where you want to look at what do we want to do in the next 5 years with personal information that we might not necessarily be doing today, and disclose that in your privacy policy. Additionally, I would say under Colorado and Connecticut, there's an additional requirement beyond that says that if you're going to use personal information for a new use that's not disclosed in that privacy notice, you're going to have to obtain direct consent from the user. This is another European concept.
Yep. Let's see what else to pick out here. Let's talk about the appeal right. This is new. This is unexpected. Not even European law has an appeal right. So why don't you talk about that one?
Yeah, appeal right is somewhat of a strange animal, and this is a complete American innovation. We saw it for the first time in the Virginia law, and it was definitely an eyebrow raiser at the time. Essentially, under the appeal right, you have to create a secondary business process for your data subject rights, where if you deny someone's request to either delete their information or to access a copy of their information or so on and so forth, they have to be able to appeal that decision into your organization for a secondary review, and you have to render an opinion saying, yes, they're entitled to that deletion, we were wrong, or no, we weren't. Personally, I expect this to be mostly an empty exercise, as you'll probably get it right the first time.
So that begs the question of how much process do you need to build around your appeal right? So what I think is yes, ideally your first level process gets the answer correct when you're dealing with data subject rights, but don't make any mistake about it. I think the appeal process has to be somehow within your organization a good faith, independent, fresh look at the original handling of the data subject request. And if it's not that, it's not an appeal process. There's the question, the law does not define what particular procedures, who needs to own the appeals process. And so I think at the moment, companies have significant leeway to define their own process, but it does need to be independent, good faith, a hard look. And note, if you continue to deny the data subject request, at least in the case of Virginia, I don't recall off the top of my head the other laws, but at least in the case of Virginia, you have to tell the consumer how to contact the Attorney General so they can make a complaint, presumably, to the Attorney General. So the appeal process kind of implicitly invites at the end direct Attorney General regulatory oversight of how you're handling these consumers.
I believe that's the case for all three.
Okay.
Another important process that now has to be created within the business is that you need to get opt-in consent to collect that sensitive personal information we discussed earlier. This is a requirement specifically in Virginia, Colorado, and Connecticut, which all tend to cohere very closely together in terms of their provisions. So if you ever have a need to process something such as racial data or to process maybe somebody's union membership information, you have to get that consent directly from the consumer saying, hey, we want to take a look at your health diagnosis. Is that okay? Opt in, opt out. Additionally, Utah and California, well, they don't require you to directly approach the consumer and get their consent to use this information on an opt-in basis. You have to allow them to withdraw that consent that you've inferred.
Yeah, that's right. The last thing, and then we'll move on because we spent a lot of time on this slide, but note California, there is a requirement to state your data retention policies, and they want a number there or they want a criteria. They don't want the statement, we may retain data in accordance with law. They want you to actually go through the exercise and think about what data you have, how long you're retaining it, and then to make a public commitment around that. So that's, we'll come back to that.
This is another European concept.
Yeah. All right, so finally, Jordan's gonna run us through enforcement and penalties, and she's gonna do it in 2 minutes.
Okay. So each state law tasks the Attorney General in each state to enforce these laws with special attention to California and Colorado. Colorado's district attorneys may also enforce the state privacy law. And in California, the California Privacy Protection Agency is an independent watchdog agency tasked with enforcing the law as well as informing businesses and consumers about their respective obligations and rights.
And note that these laws, another fantastic American innovation, as far as I know, I'm not aware of it from any prior law, these laws have self-funding mechanisms. So fines that are recovered under these laws in many cases go directly to funding and supporting the operations of the enforcement agency for further enforcement actions. So there may well be a snowball effect over the years, especially in California, where you have a dedicated regulator and a built-in funding mechanism for enforcement that only gets larger as they manage to levy larger and larger fines.
Right.
Anything else we should know crucial about enforcement and penalties, Jordan?
Well, as you can see on the slide, there are civil penalties for each violation per consumer range as low as $2,500 in California to $50,000 in Connecticut. I will also just briefly note that no other state besides California provides for a private right of action for consumers except for data breaches that impact personal information in California.
Yep.
And statutory damages range from $100 to $750 or actual damages, whichever is greater.
So note it's no express private right of action. There is an argument that private rights of action will be possible under all of these laws under the state's Unfair and Deceptive Trade Practices Act, notwithstanding that the laws themselves don't have an express enablement of that.
And some directly disclaim it.
Which interestingly, California had a disclaimer in their law, and that did not stop plaintiffs' lawyers in the first round from bringing private actions and citing the law's authority for those actions.
And perhaps we should note before we move on that these laws are not. This isn't $700. This isn't you get caught $7,500. Thanks. Have a great day.
Yeah.
Likely when the Attorney General or the California privacy protection agency pursues you, it's going to be each day may qualify as a separate violation. Each data record sold in a record of 50,000
Each
might qualify as
individual
an
affected.
Yep.
Yep. So the per violation is important because it's kind of an endlessly arguable concept. And that combined with other aspects of the enforcement means that these are not total penalties. This is just the number you find in the statute. And anyone who's tracked enforcement in a law like like FTC laws, right, or unfair and deceptive trade practices laws, knows that the total assessed penalties, expenses, costs, fines can make these numbers meaningless. Like Facebook got assessed a $5 billion penalty a few years ago from the FTC. You do not find the numbers billions in the FTC Act under which. So regulators will find a way to assess penalties if they think it serves them or you deserve it.
I believe that was the settlement amount. It served.
That may be right. Tells you something. So, all right. So finally, but not leastly, we're going to talk about how to approach compliance within your company. So first step is to have some working around analysis of the applicability of these laws in your context. So consider the number of consumers you have, your revenue, the kinds of customers you have, whether they're consumers or business, whether you're operating in a regulated area like healthcare or education where you might have a special exemption, and then form a walking around analysis, I'll call it, of the scope of these laws. Then start thinking about, you could think about this simultaneously, your data processes. What do you collect? From whom do you collect it? For what purpose? And you need to think here broadly about your marketing, your internet, your operations, your third-party relationships, right? You may have referral relationships or partnership relationships where data gets shared in some way. And you have to understand all of those. You have to understand those processes and the data elements involved in those processes. Once you've done that, you can now refine your legal analysis. Start thinking about the particular materials that you're going to have to produce, right? The particular notices, for example, the particular consents that your business is going to have to produce to your consumers. And then start thinking about the practices you're going to have to build or change or eliminate. Are you going to start collecting less information now in some areas? Are you going to restrict your collection of sensitive information, for example? Are you going to have to build an appeals process to your existing data subject rights process? Are you going to have to build a data subject rights process in these states? You can start to answer those questions. Answering those questions is what then gives you what I call the project plan, right? The actual actionable to-do list of items. This is the notice we're going to produce. This is the business process we're going to put in place. This is the policy we're going to update. This is the data collection practices we're going to change and confirm. This is the contractual, we're going to build a data protection addendum as a defensive maneuver, right, against our business customers, so that we're proposing something to them before they start proposing things we can't deal with to us. You start confirming the concrete plan. And then the last item isn't really something that happens at one point in time. It's important as a general feature of your overall program structure. You for this project to have any chance of success, you have got to define and assign ownership and accountability within the company, not to outside counsel, not to outside consultants, not to your auditors. Within the company, someone has to be accountable for owning the program and for owning the particular project elements. And you could separate those two. You could have someone responsible for overall compliance and maybe someone else is responsible for executing on the project plan. But if you don't have that kind of clear ownership and accountability structure, you're not going to succeed. So on the final slide, I've given some illustrative project plan elements, right? So this is what your project plan, the kinds of ingredients that will go to make up your final project plan. It will be things like updating notices, preparing offline notices. If you engage in sweepstakes or promotions, there may be a special kind of financial notice you need to provide under California law. The data impact assessments that Nick mentioned, the opt-outs that Nick mentioned, consent processes, the data rights procedures. You also consider developing like a negotiation playbook for your business customers. So if you haven't already, you're going to start seeing your business customers imposing data protection addenda on you that increasingly reflect the requirements of these laws. It's predictable to a large degree what issues you're going to face in those negotiations. We can generally predict today probably like the top 10 issues you're going to face. Maybe even we could expand it to like a top 15 or top 20. Consider whether you develop defined, consistent positions and develop a negotiating playbook to support your frontline customers. Otherwise, you end up in a position where you're not treating your customers consistently. You're doing one thing for one customer, another thing for another customer. It's very hard to implement discipline. That can be an issue in two different ways. One, it becomes an issue because you're just not able to live up to different inconsistent commitments you've made to your customers. The second is if you're contemplating an exit event for your company, one of the things that does get diligenced and reviewed in a privacy and cyber diligence typically is how disciplined you've been in your contracting and whether you have an approach with your customers that can be easily understood and make sense in some rational way for the business, or is it a spaghetti approach, right? An approach of we did something different for every customer and we took on different amounts of risk for every customer, and good luck potential purchaser sorting out what we've done. It becomes at least an issue, a potential issue in an exit event. Occasionally, even I've seen it become an absolute bar if sort of critical contracting has been handled badly enough. So that is the end of the presentation. We promised 30 minutes. We went a couple minutes over. I do appreciate everyone's attention. Do feel free to contact any one of us. If you have any follow-up or questions, we're of course always happy to engage. Thank you, everyone. And with that, I think we will close the presentation. Thank you, everyone.